Prior art. What we have seen so far is the fact that invention advances technology. An invention results in a progress of a technology. Technology advances by way of the invention. How do we know this? We know this when we compare the invention with what has gone before in the field of technology. Now, the knowledge that has gone before in the field of technology is referred to as prior art. Alternatively, it is also referred to as state of the art or background art. Now, you will find that the word prior art figures in the Patents Act. This is a copy of the Patents Act, and we are in section 2 where the definition of new invention is mentioned here. A new invention means an invention or technology which has not been anticipated by publication in any document or used in the country or elsewhere in the world before the date of filing the patent application with complete specification. That is, this is the critical part. The subject matter of the patent has not fallen in public domain, or that it does not form part of the state of the art. So you find mention of the term state of the art, which we have just mentioned is nothing but prior art, in the Patents Act. The Patents Act also mentions prior art in the context of multiple priorities. We will come to that later, but prior art or state of the art is what has gone in that particular field before the invention came into being. And in fact, the invention is constantly covered with the prior art. Now, if you look at a definition for prior art, and one definition that's available for us is the definition in the European Patent Office website. Now, it defines prior art as any evidence that your invention is already known. So by prior art, we are referring to some kind of evidence. Now, in law, an evidence can either broadly fall within the category of an oral evidence, which is what people say, and it could be documentary evidence, evidence that is documented. So prior art in patent law, predominantly we are talking about documentary evidence against your invention or something which shows that your invention is already known. Now, it does not need that the prior art should physically exist or it should be commercially available in the form of a sale. It is enough that somebody has described it or shown it or used the technology. Now, you could say there are many things that could amount to prior art. A cave painting can amount to a prior art. Instruction manual can amount to a prior art. A thesis lying in a library, an unpublished thesis, can amount to a prior art. In fact, anything that has the value of an evidence can amount to a prior art.